Can everyone hear a little bit better now? I'm getting head nods, so good. Okay. With that, I agree. Chairman Watson will hold off on the indigency language since some people just got it, may even still be reviewing it. And let's move on to, let's go ahead and just do our presentations. I think that'll be helpful to kind of open everything up. And then we can jump back into the indigency definition and go through the numbers provided by the various courts as well as the Department of Safety. So our first presentation that we are going to have, let's go with the CIIM presentation. I believe they're going to be doing it virtually via Teams. So you'll be able to see the information up here. And we'll start with that because the presentation from the, one second, the one with David Connor, I believe that was just information that he provided. I don't believe he was actually going to go through any information. I think that was provided by the courts. And so we will start with the CIIM presentation and get going there. And I'll ask that they go through their presentation, and then it's up to the body. If y'all want to stop with questions you may have or hold until the end, I'll let that kind of be y'all's decision. But with that, go for it. I think, Brandon, y'all are going to be doing that presentation.
Good morning, everybody. Thank you very much for having us. My name is Brandon Ross, and I work on behalf of the Coalition for Ignition Interlock Manufacturers. I have with me here today Chad Ross, who is a practicing criminal defense lawyer. We have been in the electronic monitoring and ignition interlock business for about 12 years now. So we just have some ideas, some thoughts that we have come across, and I thought maybe we're happy to answer any questions you may have from an industry standpoint, but also I thought it would be helpful for us to have Chad here as a practicing lawyer who can perhaps shed some light on what he deals with on a regular basis with this in the court system. So we'll just get into it. And if you guys have questions along the way, just yell and stop me. Otherwise, we can revisit them at the end too. So the first point we've got is, I think without being too negative, I think we made a mistake by marrying the funds years ago, and we feel that breaking them apart and having separate ignition interlock and alternative monitoring as two separate funds would be beneficial for us to understand where exactly the deficiencies are coming from and what our resources are. We can say that less than 10% of our current active indigent clients for ignition interlock pay something towards his or her program. So less than 10%. We feel like many judges simply are not aware that he or she can make the client pay something. And that can be any amount of their choosing. So I hate to be redundant if this has been discussed before, but the judge has the opportunity to essentially have the offender pay something towards their program. It could be $5, it could be $30, it could be half, 50. But we also feel that as an industry, giving the client skin in the game really does help them with changing the behaviors and using the technology in the way it's designed to work. Quite frankly, if they think that everything's paid for, I feel like the consensus is, well, I'll just get through this as quick as I can, where we find that folks who have to pay kind of have more skin in the game and more success, I feel like, with changing of the behaviors. We do hear, and this is all local to Tennessee too. We hear, and by the way, Chad and I share locations all across the state, from Johnson City to Memphis and everywhere in between. We do hear from a lot of clients. I'm sorry?
Someone just called. It's okay.
Okay, sorry. We do hear from a lot of clients across the state through our in-house compliance folks, even at the store level, just in dealings with our call centers, things like that, that clients have to go pick up their indigent paperwork, fill it out, and take it back to the clerk's office for the judge to sign. And in this case, I don't know, perhaps Chad can shed some light on this for us, but if that's the case, are we really verifying that we are in fact using the true definition of indigency and truly looking at the income and basing it on the federal poverty guidelines that I know the indigent funding is supposed to address? So another idea we have that's a little bit frustrating for I think all of the parties across the state is we have clients that come in vehicles that seemingly probably shouldn't be indigent. I understand it's not, you know, a store's responsibility or the manufacturer. This is the judge. This is between the judge and the offender and the client and the attorney. But seemingly we have some frustration with folks coming in with some vehicles that really kind of throw us off on, you know, how did this person really get indigent? And I can't tell you that it's a 2020 BMW or, you know, a 2021 Dodge Ram, but I think it does really kind of make you question at times kind of how that program works when we have some of these vehicles and we question, you know, when they drive that vehicle, would they really qualify for indigency status? And then last, and then we can go over some other ideas or brainstorm or whatever. But, you know, another thought too, going back to breaking apart the funds and having a true understanding of deficiencies. We have actually talked to, and I think Leader Lambert has brought that to me and Chad's attention several times about potentially increasing the fees on the court costs that would be paid into the indigent fund to help make it whole. And so we've kicked that idea around a little bit. I don't know how far that's gotten with you. Obviously, this is our first meeting with you guys. We don't know what exactly you all have kicked around, but that's been brought up before. So with that said, what questions can we or Chad or as an industry answer for you guys?
Hey, Brandon, this is Roy West with Department of Treasury. Good to see you again. You know, I just wanted to ask a little bit more about how separating the two funds in your mind and in the mind of the manufacturers, that would be beneficial. I'm trying to see how we could provide some more transparency into what we have available, because currently the fund, the Interlock portion is the first, you know, account. So it gets all the money, and then any remaining money goes to the non-Interlock devices. We at the Department of Treasury use the same staff to process both applications and claims, and that helps us to manage, you know, ebb and flow of claims. I'm sure everyone's aware that, you know, there's some up and down in claims processing. So I'd like to just understand from your perspective what needs to be done to make that a little bit better.
Well, again, it was just an idea, and I know we need expertise from everybody participating here today. And by the way, good to see you again too. Thanks for having me today, having us today. When we talk about this, seemingly, this subject has been kicked around for years. I mean, going back to, you know, Chad and I would have discussions with Representative Lambert back in 16, where we had a $1.2 million surplus in that account. Now, I know that back when we had all those surpluses many years ago, lots of that funding was allocated to some sort of hospital situation in Memphis, I feel like. But nonetheless, I remember conversations where we would talk, okay, there's $300,000 of that 1.2 million that's going to have to eventually be sent over to whatever that whatever that category was, nonetheless, still leaving us with an $800, $900, $700,000 surplus. And it seems to me, and I believe it was then, I think it was Gowen's bill that married the two funds together and made it become electronic, the EMIF fund as we have it today. And in our minds, and please correct us if we're wrong, or correct me if I'm wrong, it seems like ever since that happened, this has now become like an ongoing kind of mess that now we're dealing with. So with that said, if we unmarry the funds, or do we have data right now that tells us right now what's coming out for Ignition Interlock, and what is coming out, and what's going in for Ignition Interlock, and what's going out for alternative monitoring, and what's coming in for alternative monitoring? Is that data very clear to us? And if so, we have not seen it as an industry.
Yeah, I think those are good points. And you are correct. We do have that available. We provided that at the last meeting, so we can get that to you. But I think currently, if you look at, and I think you're correct, ever since the non-interlock devices or other monitoring were added, there was a increase in the amount of funding that left the program. And we went from a surplus state to a deficit state. And that is the reason why we've moved to separate the two funds internally. And additionally, if you look at the amount of funding that's coming in for Interlock and leaving for Interlock, Interlock is not, the revenues are not paying for the Interlock devices either. And the appropriations that come from the General Assembly go directly to Interlock first, and then the spillover goes to pay for non-Interlock. But we can definitely get you all that data so that you can see what everyone else on the task force has seen this last meeting.
Just briefly, so I have an idea, is the deficiency is it higher with Interlock, or is it higher with alternative monitoring?
Well, this is Eric and with Treasury as well. I can kind of chime in on that somewhat. So the non-interlock devices are funded 50% by the county fees. So we're only having to pay for 50% of then for non-interlock devices. The counties are funding the rest of that. So if you look at the amount of revenue, and this is in this document, so we can reshare with you that we provided last week for fiscal year 2021. Total revenue was $635,000. If you back out the county revenue out of that, which was $286,000, you're looking at $350,000 in total revenue from court fees and a small amount of interest. Interlock devices, the cost for those alone was $530,000 last year. So if you just look at just interlock devices alone, those outspent the revenue that came in last year, just on interlock. Non-interlock was $582,286, so half of that came from the county. But the first part of all the revenue does go to interlock devices. So we're out in interlock devices. The usage of that has doubled essentially from 2019. In 2019, we were at interlock devices were 383,000. 2020, 739,000. 2021, we were at 530,000. 2022, we were at 689,000. So we've more than, the past 3 years have doubled essentially what we're used to at the expenses and payments for interlock devices. The revenues have increased slightly. They've only increased, those DI court fees have only increased maybe 10, 20,000 a year. So while the court fees, are about 2021 court fees were $342,000, and then we had $6,800 in other court fees. We had $530,000 in interlock expenses. So we do have the accounting to break that out and show that there's been a huge influx in interlock devices. That has also accounted for this change in how the revenue is spent and where we were and where we used to have a surplus and now a shortfall.
This is Judge Statham. I'm a general sessions judge. I'm here with Judge McVeigh. One of the reasons it's increased was a change in the law. Used to, you could wait till your year was up and you didn't have to have an interlock. Now, if you wait till your year's up, you still have to have an interlock for a year. And so that accounts for a substantial amount in the change that I don't think everybody realizes.
We didn't have any revenue
Right.
increases to
There was
offset
no
the
revenue increase to support that change. And now the laws changed yet again. On a second offense or greater, it says the judge shall, unless there's other reasons to the interest of justice, the pretrial are requiring an interlock. So it's going to increase even more.
And again, I'll add, this is Judge McVeigh on behalf of the General Sessions Board. Again, just so we're aware as well, on these pretrial devices, if we start using them pretrial, that interlock device, there will be no court costs because there's been no adjudication. Somebody actually might be found not guilty of the underlying offense. So again, there will not be an increase in court cost revenue if somebody's ultimately found, adjudicated not guilty or the case is somehow dismissed. So again, I mean, as far as projections, I mean, I think you can continue to see some additional costs and no court costs offset.
This is John Gleason. There obviously is a problem with the court fees funding everything, but those specific pretrial ones are funded by direct appropriation, not the court fee. So,
and will that be set out separately in the statistics, hopefully? So I'm just again in the future when we're seeing why, I guess that is a good point to make, and just to make sure it's separated out on their statistics as well.
What did we budget for that?
it was very
10,000?
low for this first year.
10,000.
Oh, my goodness.
Yeah, it's very low.
I'm even close to covered.
Well, when you're talking the number, and we kind of stayed out of that bill because it doesn't touch convictions. It's only at arrest. We have, what's our average DUI arrest number versus conviction number? So you'd have to, we have about 10,000 on Interlock now. And if you're looking at arrest versus conviction, you could then assume that a lot of those arrests are now going to have Interlock paid for it, and there may not even be a corresponding conviction. So that's just going to deplete the fund more.
Judge Statham and Judge McVeigh, in your court systems, do you require any type of documentation of the offender or the individual who is claiming indigency status to provide income information from a local standpoint here in Sumner County? Right.
Y'all have the form, right, as far as the affidavit that they swear to. I mean, we have a hearing on every individual. So I saw there was a note that there are a lot of counties do not have any hearings. We have a hearing on every individual now. Evidence that might later present like their actual, they bring in a BMW to you guys. I mean, if that wasn't presented at the hearing, then obviously we have no, we don't know about that. And it is rare that we have a subsequent hearing based on additional evidence that might come to light. I don't think we're prevented from having that hearing, but we have a hearing and we go ahead and go through the uniform affidavit of indigency for the purposes of electronic monitoring. That's, I think, in your chat. We go through that, with every individual that's requesting any sort of assistance.
But it doesn't ask those questions. See, it's different from the affidavit of indigency that we require for appointing an attorney. It only asks how much income you make, how many persons live in your house, and then you go down to the back and it says, do they meet the guidelines, the poverty guidelines? And if they do, then we assess how much money based on that, but it doesn't provide us with any factors we should consider other than we can look at the affidavit of indigency for appointing attorneys. But there's no other questions that it requires that we ask.
And again, some of us do still go, ask additional questions and use the Supreme Court's affidavit, since we're used to using that one and those questions. But also, I mean, I know for me, I have never not made a defendant pay something. So again, I think with that information that you, Brandon, gave us earlier, that only 10% are having folks, I mean, that's certainly something that we need to address with our judges in the conference, because I know personally, I have never let a defendant pay $0 when they're filling this out. So if that's happening across the state, then obviously we need to be aware of that.
And one more thing too, to your point, Judge, I like to bring up, because this is something too that we've been asked, to our knowledge as an industry, and I'm talking about just some of the manufacturers have alternative monitoring. It's not nearly as big as like a alcohol monitoring bracelet, but some of the Interlock folks do provide other products, just so you're aware. But specific to Ignition Interlock, you mentioned a law change to where all of a sudden they couldn't wait out any longer. That law changed in 2016. To our knowledge, yes, we had an influx of Ignition Interlock client base, but that number has actually decreased. And based on the numbers we've got from Mr. West, the indigent usage is going up. So, and Ms. Stroker, I think, can probably tell us all exactly how many Ignition Interlocks there are being monitored across the state. But that number has stayed pretty solid and even decreased, as far as we understand, in the state of Tennessee, not substantially, but maybe 10%, 12% down over the course of the last 2 years. So as an industry, we feel like we're just using more of the fund. I don't personally believe that it's additional people using Ignition Interlock. I think it's additional people utilizing the Ignition Interlock fund.
Yeah, and I believe our numbers, and again, it should have been in this packet, but I did send it out. Our numbers are showing that the number of people on Interlock stays pretty consistent around 10,000. So it does appear that it may also just be based on the treasurer's numbers that it's more people claiming the indigency fund as well. But I will say, in the court's defense, because I have to deal with, for the best word, all of these convictions, it took about 4 years, 3 or 4 years, for everyone to realize the law change from 16. So there were a lot of people who came in 18, 19, and 20 who thought they had done their requirement and they hadn't, because either the courts or the DAs or the defense attorneys didn't understand that you couldn't sit it out any longer. So that could also attribute to it as well, is that we had a lot of people who thought they didn't have to do Interlock and then found out a couple years later that they actually did.
And
so
that still persists.
that's still a problem.
If it's a plea agreement and the district attorney does not make it part of that plea agreement that they are mandated, I mean, it's a Department of Safety requirement, but it's not a requirement for their ultimate plea agreement or their conviction. So a lot of defendants still, I mean, I try to remind them, when they're taking, now this isn't part of your plea, but just so you know, you have to have that on your vehicle for a year before, so, but that's just me reminding folks, as opposed to actually being a part of those plea agreements.
Yeah, and I still probably get at least a couple a month where either the defense attorney, DA, or the court didn't realize that it couldn't be waived. And we have to come on the back end and say, oh, no, you should have had Interlock a year ago. And then they're like, okay, well, how do I figure out how to pay for it? And then they go through the indigency fund. So it's a lot of people who also are getting it outside of the time period they should have got it, which probably doesn't help with those numbers either. But that has gotten a lot better. So there's the progress there. I'm also pulling up those law changes from 16 and the one from this year. I'm going to put those in the chat. Senator Watson requested the public chapter as well as the fiscal notes for each. So while we're discussing, I'm going to pull those up as well. If we,
created the uniform affidavit indigency for appointment of attorneys, it was the Supreme Court. From the other affidavit, the indigency fund, I think that was created under the authority of 5510-419E.
Is it the comptroller's office?
And it looks like the comptroller.
Well, that's the poverty guidelines. I mean, who actually prints it? I mean, Charlie, are you on here from the AOC or somebody? I mean, who actually, I know they send us those forms, but as far as who actually made the document, does anybody know for that indigency affidavit? I know we get it from the AOC, but
Yes, this is John Gleason, Tennessee Code annotated section 5510-419, which is the EMIF statute, subsection E says, every person who informs the court that the person is financially unable to pay for a functioning ignition interlock device shall be required to complete an affidavit of indigency that is designed by the administrative office of the courts for purposes of assisting the court in making its determination pursuant to subsection C. And the only thing that the statute requires is that the person is indigent and financially unable to pay for a functioning ignition interlock device if the person is receiving an annual income after taxes of 180% or less of the poverty guidelines updated periodically in the Federal Register by the United States Department of Health and Human Services under the authority of 42 USC section 9902. So that's why it's different than the Supreme Court indigency for an attorney, which is a different code section.
Right, so the statute would have to be amended for us basically to ask more questions.
It's also interesting to note the statute only technically requires that for ignition interlock specifically. It does not say ignition interlock or other monitoring device.
Do we have any other comments or questions from or for the Ignition Interlock group that's here presenting?
Thank you both for your time. I appreciate y'all taking time out of your day to be here with us. It means a lot just to get another perspective and stuff. So thank you so much.
The other potential presentation we have is from all of the information provided by the Treasurer's Office. It's this form, I think, that was referred to earlier that's in your packet. And again, this was only provided. It's not anything that necessarily has to be presented, but if we want to go through it, this came from, and I think y'all were hinting at it earlier, from Mr. Connor, and this is what they use, the guidelines. Oh, it's got your seal on it. Yeah. It's the second that all that.
Oh, yeah, I'm sorry. Yeah, this was. We read it. This one read in the first meeting?
No, this was separate. Just if,
This is the comptroller, not the treasurer's office.
sorry,
Sorry.
yep, that would be exactly why. I'm looking at the wrong thing, but I don't see David on here, and I think he wanted to kind of go through this. I don't know if someone wants.
This is John Gleason.
Okay.
I think all he was probably going to point out is the fact that, as we've discussed previously, the comptroller's audit found that not every court was using the uniform form. Some were using other forms that were substantially similar, but not the same. They were not having independent hearings to determine indigency. They were just doing it in the course of the hearing the person was there for. But that judges, public defenders, and prosecutors reported that in their experience, a great majority of persons receiving appointed counsel are eligible, and that the cost of establishing a more thorough screening system could be greater than the potential savings. So it seemed that although they knew that they weren't independently determined indigency, that they felt that more often than not, the people were actually indigent, and having an independent system to determine indigency would be more costly than the money they would be saving through the independent system. But the task force, which is the Indigent Representation Task Force, did still recommend Quote, clear criteria for the entitlement to appointed counsel should be developed, including certain presumptions for eligibility, such as income thresholds or other qualifying metrics, such as eligibility for public assistance, which, as Grant pointed out, is clear in this their proposed definition of agency does have food stamps on there, public housing, poverty guidelines. It's got all those sort of different things.
I don't know if they're using a form, but I know talking to some of my judges, not session judges, but circuit judges, and asking these questions in a little different set of circumstances when it's a civil judge looking at a child support and other things, but they ask for proof of do you have a cell phone? Do you have a car? You're living somewhere, or you paying rent? And if they do, they make them pay something. I appreciate the two judges here from Hamilton County saying that in Hamilton County, at least, they're required to pay something, even if it's just a few dollars a month. At least they've got some skin in the game. I know we're going to get into this a little bit later, but kind of the elephant in the room, from my perspective, is when you look at these numbers from across the state, any definition of agency is not being applied consistently. Period. When you see a county that has, a fourth of the population of another county that's using twice as much of an agency fund as the other county that has 4 times the population, something's not being applied consistently. When you see those numbers, period, you can't pull it. And the numbers should reflect, with some small variations based, different poverty rate from, a small rural Cumberland Plateau County versus affluent Donut County around Nashville. The numbers may vary somewhat, but they're not going to be that big of differences between them. There can't be. And so, we can talk all day. We need to come down with a good definition of agency, a form that's used across the state. And we got to come up with some way to make sure the judges are applying it and using it. That's what we need to talk about. That's the main reason, Katie, I wanted y'all here. How can we, I remember, I don't have it in front of me, but looking at Hancock County, I think Hancock County was one of the huge outliers. They are Hawkins County, huge outliers. From a casual, glance, I would say there's a judge there not using any standard for agency other than somebody just saying I can't pay.
It only requires that they put in the amount of money under the law that they make and how many people in the house. So we might need to look at what their income level is in that county. It might be a lot less, but that might explain.
And there's just some additional questions that were maybe laid out in the statute or that these judges could follow more clearly on that affidavit.
Right.
Certainly be helpful. And just so you know, Judge Statham is the president. Every single, at least general sessions judge, will be together in September for our conference. We meet twice a year. The circuit judges, criminal judges meet twice a year. But every new judge in the entire state that was elected in August will be in Chattanooga. There's no virtual option, but everyone will be together in September, late September. So again, if these numbers need to be shared in some sort of presentation, if other ideas about what we may or may be doing incorrectly or correctly needs to be, obviously AOC helps with that conference, and so I don't disagree. Without pointing out some judge in particular,
right.
Talking about, but maybe that also needs to happen. I don't.
And this is Holly Kirby with the trial judge. I represent the Trial Judges Association. Alex, I think we're in the same boat as you guys. So you just let us know. I'm obviously not in a position to tell you what any of our judges are doing at this moment, but I can certainly make sure we get the right folks to get the right numbers and anything that we need. I'm happy to be a resource.
And I think just based off the meeting last week, we invited the judges' representatives this week to hear this conversation, to hear the conversation around the definition of indigency and how it's being used, with the expectation that at the next meeting, you all would maybe be able to present something or provide more information to the task force on how this is being used and if it is being used differently, which I think everyone agrees is pretty clear. And then, so they have that information to kind of move forward.
Would it, since everyone can hear now, would it be better to move back to this topic of definition?
We've got it pulled up on the screen here for everyone to see in the room. Senator Watson, I'll defer to you. Is the sound okay now for us to move back to that, or would you prefer that we move or save that for later?
The sound is much better. I don't know that I have a copy of the definition that Grant was referring to. I looked at a couple of documents that had been sent to me by you, Elizabeth, that look like they were pre-existing documents about indigency, but I'm not sure that I have the definition.
I am sending it to you right now to your Capital email address. It just got sent. And then it's also in the chat for anyone else who may need it from the chat as well.
I believe it's in the chat, the message that was sent at 9:17. If anybody's trying to find it in the chat, I know there's several files there.
Yeah, just for y'all's notice, some of us that may be using our iPads to watch this, some of those files that you're sending in the chat won't open up for us.
Oh yeah, iPad will not open up a PDF file. So y'all let us know and we will send them out separately to an email address. James is sending those right now to those who are sending. They can't see them.
Ms. Stroker, is there a way for you to allow us access to open them? We can see them, but we can't open them during the, is that an access thing?
Yeah, we've also got it shared on the screen here so everyone can see it as well, if that's easier.
Oh, there it is now. Got it. Okay, thank you.
All right, with that, we'll jump back to that first thing on our agenda and we'll open it up for the discussion of the definition itself.
Yeah, just to circle back, this was something in our office drafted to really provide something in code that could be pointed to as it's implemented in different programs. So it's certainly still in draft form if anyone has significant feedback. And we wanted to make it the points 1, 2, 3 kind of or situation to provide flexibility to be implemented in different ways. So that was the intent here. I know it's not necessarily the silver bullet to this conversation, but seemed to be something that we could add to the statute potentially at some point, just to have folks be able to point to it and build out their programs from there. So. Also, one point we sent around definition from various states. We can send that again. Maybe at the end of this, we just package everything together and send it out to everybody. So,
yep.
You know, everyone's got everything, but that 150% highlighted number is something that was, there's kind of a range among different states that was anywhere between that 150 and 185, something around like that.
Yeah, 185 is our current EMIF.
Elizabeth, I should know this. So what's the month, the cost a month?
And actually, Brandon and Chad, y'all may be able to correct me here. It depends on the service that you're doing. So, and Kevin, I think you know these numbers for sure. We have it capped of how much you can charge for initial install, which is I think 175, and then there's an hour limit on it. And then there's a removal fee that's also capped, but then monthly there's calibration charges that can't be more than 125.
Yes.
So up to 125 is the max per month. Mm-hmm.
Okay.
And those fees were increased in 2020.
I don't have it off the top of my head. I can pull the statute, but the EMIF statute has a cap of how much per month.
I think the statute says
200 for all devices.
That's correct. Maximum 200 for alternative. Ignition Interlock can't max that out because it's regulated, as Ms. Stroker said, at the 125.
And so when we look at the total universe of people who are wearing the monitors, how many of them are paying the full amount? How many of them are paying nothing, and how many are paying a graduated amount, like what's happening in Hamilton County, I'm sure other counties as well, where the judges are at least making them pay something. But I'm looking at this criteria here. My first question, and I know, talking to one of my judges back home, he'll ask the person, you got a cell phone? Again, you got a car? Well, you're getting other income. You're able to pay $100 a month for a cell phone.
And I think that's where he comes in, the governor's office is that it's a kind of a rebuttable presumption. So the presumption might be, but then other evidence, again, so long as it's clear to everybody that other evidence can be introduced, other questions can be asked, other evidence could be required of the judge, then I don't think this necessarily limits us so long as those other things are happening. Because yeah, I mean, how do we, I mean, if someone's the folks we're dealing with every day are likely gonna also lie even on a sworn affidavit. So I mean, it's, so that's, it's just, but to your point, what else could we be doing?
Right. And if there's something else that we need, or they need, since I won't be there, the legislature needs to put in statute to provide more clear direction.
I do think we need to include the number of people in the household somehow.
Is that the guide? I think that falls right under the guideline.
Well, it's less than that. Well, if you look at the form now, it's got the amount
I think that's
with the number of people, and you weigh the number of people. So if they check that,
I think that's factored into the poverty guideline because it's that amount of money for a household.
That is what sorry. I think that's what it includes. That's 3. Yeah, years. They'll still have this form.
okay, as long as we can.
Okay.
And then the definition of public housing, are they living, maybe needs to be changed somewhat because, we have people in section A, is that included?
There's a lot of assistance, even COVID assistance. Is that going to be, if it comes from any sort of grant, would that be all public housing? Again, or you might want to keep it vague and leave that up to the judge, but whenever you leave something vague, just know you might get differing results across the state.
The potential problem I see, Grant, with definition is if we were to adopt this, we had previously spoken about having someone checking on the back end to make sure. Well, if we have, federal and state assistance, public housing, or poverty guidelines, then you now have a significant higher amount of people that have to check different things, whereas just checking the poverty level, like right now, try to tie it to SNAP eligibility, checking that was much easier. Okay, so if we have an expanded definition and we add the backstop, and that's just, it's gonna cost us more to fund those people who are checking all of those things. So we just need to be aware.
Would having this different criteria make it easier on the front end to more flexible necessarily, or would it potentially be better to, or does it depend on the program?
It depends on the program you're using.
Well, I think again, it provides us with a starting point or the affidavit, a starting point in which to question. But again, I think what the big issue is verifying on the back end and how does that look like? And I guess you guys talked about that previously, or are going to talk about ways to bring to a judge's attention, potential, incorrect statements in that affidavit, but how to verify that, or how to provide judges with, more guidance as to questions that do their own investigation and require that. So I don't know the answer to that. I mean, this, to me, at first glance, it reduces at least slightly the 185 to 150, which, I think would, certainly maybe less folks would fall into that, or it also at least, brings to light some other questions that judges can be going through and asking. But again, I don't know if it solves the bigger problem. Judge, I think Senator Bell was great.
Let me ask something in your, maybe people want to, how many DUI cases do you hear a month? Or a week?
Wait.
I don't know, this could vary.
between all of us.
Oh, all of you, not individually, but all of you, 50 in that count. Okay.
But now they're reset.
Right.
On
yeah.
Wednesdays, we have quite a few. I would say 50.
I mean, I had close to 50 on my last Wednesday's docket, but again, those were on one day's docket, at least 50 DUIs, probably I had about 150 cases on the entire docket, but those were cases that were reset. So initial settings where, you might be, well, again, I guess this is going to come into effect when that person actually pleads guilty or after that trial, when they're found guilty, and that device is then required, unless we're talking about the pre-trial. But assuming we're just talking about post-trial, that's going to happen when they're ultimately, which we are going to, I think this number, I think we're in for a bit of a shock in 2022. Over the last 2 years, most DUIs and all cases have been intentionally passed because of COVID, and defense attorneys and they've been passing cases. And I think you're going to see a big uptick in ultimate convictions that, so we might be very surprised in 2022, 2023, how high our numbers are. So again, just another cause for potential concern as far as the fund's concerned, because a lot of these cases, I know I have 2-year-old cases that I'm enforcing now. You must have a hearing today or have some plea agreement. So I think we're going to be seeing that across the state, a big old uptick in DUI convictions next year.
Plus, you see the numbers went down because they were making less arrests during COVID, and now it's.
But also just passing them out too. The new cases are just getting.
And you can see, we're sharing it here. We broke down the number of arrests and convictions since 2013, I think is when we pulled the numbers through. So, and I put that in the chat, and then I emailed it out earlier, I think last week as well. So
It was huge in Davidson, I noticed.
Yeah.
Many less were made. Ours didn't look as dramatically different.
924 is still a lot. That's pretty large. Obviously not compared to your big metro areas, but.
And the conviction numbers, have they?
Yeah.
Those are just.
These are convictions.
I'm just worried about the next year's conviction numbers. Like even look at Davidson. I mean, it's just gonna, I don't think we can expect these small numbers next year. And
well,
so again, just
even if you're looking, so now think of the bill that passed July 1. Let's see, Hamilton had 924 arrests, but only 300 convictions. So how many of those
672
right would have potentially pulled from the fund that would have never resulted in a conviction that could be eligible? So you got to consider that into the factor now as well of what's going to pull from that fund starting this month. And then same for Davidson, their arrests are 5,000 and their conviction numbers are nowhere near that. 562. Obviously it's skewed because of COVID and everything. And a lot of DUIs take multiple years to cycle through, but.
That's what I was going to point out. And I think the judge on the other end of the line, point out how some cases just tend to get reset and reset. So some of your conviction data might actually be a case from several years prior when you're looking at that, so your arrest to conviction data.
And I put that public chapter in the fiscal note in the chat as well. Also, I'll send it out with everything later. The fiscal note was about 8,000. So. And there are a lot of amendments in fiscal notes from the 2016 bill. It looks like the bulk of them are over 100,000 though. But I think most of that is due to all of the enhancements in DUI penalties as well. But I put a link to that with all of the various amendments, the public chapter and the various fiscal notes in the chat as well for everyone to see. And I'll obviously send them out with everything after the meeting concludes. So everyone has all the data from 2016 and from the bill this year.
And also just to paint this picture as well. I know a lot of problems and no solutions, but on my 150 case docket that I had last Wednesday, so 150 cases, let's use 50 DUIs, and let's say they all plead or have trials and are found guilty on that day. So on that one day, in addition to holding those DUI trials, preliminary hearings, plea agreement, enters these plea, of 150 cases, I guess at that moment, I am also then supposed to have this hearing Because that's when the majority of folks are also requesting that indigency paperwork is that court date. So just after that 150 person docket, that's also when I'm supposed to have, I guess, not only have this hearing, but then try to get additional proof in. So I'm just, so if there was a way to be, to not necessarily do these indigency hearings on the plea date or on the trial date, you're not allowed to do this until, have to specially set a hearing later on, because I mean, in circuit court, they can do it when they have one domestic case and require all this proof. So I'm just thinking logistically, how do we tell the other judges across the state, to schedule in these, well, however we make this definition, how to schedule in these hearings. And I just think, we need to, we want to see some change, give them a practice, maybe we don't do it on conviction date. You have to have a hearing at least a week later. So it can be, scheduled in. But that's going to add some additional docket days to these judges so yeah, I mean, I think it's tough, but.
Yeah, that's why the comptroller's audit said the courts also told us that holding a complete hearing would further congest the backlog of cases already in the court system.
And I think that's true. I mean, there's 5 of us. Some places just have like no judge and they're part-time.
I will say when we were going through redoing the payment plan laws or creating the payment plan with the courts to where individuals had to at least be put on a payment plan before their license could be revoked for failing to pay court fines and costs. One of the biggest issues that we ran into is for the courts trying to figure out how to do this and schedule these. Obviously, there's a lot more discretion with that because it can be, just $5, $50. And as long as they're making payments, they could keep their license. But one of the biggest pushback is we had to amend that bill and couldn't include, indigency definitions or hearing requirements because there just wasn't the time to do it. So it had to be much more discretionary.
I mean, just the thought, I mean, I know the Department of Safety does quite a few administrative hearings when it comes to forfeitures and seizures. Has anyone else ever proposed the idea of another agency actually conducting agency hearings electronically or, to assist the courts or providing, so I just, as far as ideas are concerned, I'm just thinking of ways, because I don't disagree with Chairman Bell that these things are happening differently across the state and we're draining our funds. So what are some solutions to not do that? One is to make it more clear in possibly the statute or at least in the affidavit, give the judges more, guidance and questions that they should be asking. But are there some other folks that could assist in these determinations outside of the judge if they're going to say, I don't have time, I won't do it,
So yes, like I mentioned in talking about this definition, having someone on the back end to check, the reason that came up in conversation was because in 2019, there was a bill where we tried to tie this specific indigency determination to SNAP eligibility. And it would have required the clerk, once they got that affidavit of indigency declaring that person indigent, to send that to the Department of Human Services, who would then verify that, yes, this person is eligible for SNAP, and they would send that back, and that would be kind of like a backstop verification that everything is, up to par. The problem was the clerks didn't want to do it.
And that when we were going through the payment plan bill, we had a similar issues that the clerks are already doing too much, which they are, and they just don't have the capacity. So
I'm moving on just a little bit, but this is one of the questions we always are stuck with in court of DUIs not being allowed to be on a payment plan after the year expires or 2 years, whichever. So it's first offense. That might help people make more money. And, if they could get on a payment
Contribute something to
with I don't think they're even allowed, according to the statute, for our purposes. I don't know about the court requirements, and that's something we discussed. I think it was in the last meeting or the first meeting. For DUI is weird to where if you have a DUI conviction, you have to pay all of your fines and fees in full before you can get your license reinstated.
Your full license.
Right. We can't even issue, they're not eligible for a payment plan option, or they shouldn't be.
Well, we put them on a payment plan for that year.
Oh,
that
while they're getting their
or that
restricted,
they're
yeah,
paid,
yeah.
while they've got a restricted.
Right,
They can
but
have their
after it,
restricted for a
Mhm.
year, and then boom, they have no license at all.
right,
And so a lot of them say, well, I can't get back and forth to work. So a lot of us see them and waive more of their costs to try to get them where they can pay it to get back to work. So that might be something considered. And I don't know, I'm not thinking of all the impact of if they could be on a payment plan after the year, but maybe be required to stay on the interlock longer or something to cause them to have.
no, we were discussing that. We're not really sure why that offense is different. But it is the only driving offense that requires you pay in full prior to getting your license reinstated. No others required.
So
I'm not
after,
sure
so
why.
after the year on the first offense, you're out of a license.
Right,
You
so if
get
they still
paid.
owe $400, $500.
And as far as incentives from the folks that we see, it's far, I mean, people are far more inclined to keep paying on a payment plan to keep their license than to have to go pay $4,000 on all of that DUI money on the front end. So they don't even think about, I'm just gonna keep driving without a license to work, and I'm not gonna pay any of this, and I'm gonna drive without an interlock. I mean, so I mean, it would, but I know when folks are on a payment plan, they want to make sure they're staying on that payment plan, so they keep paying something every month, and it's not a gigantic mountain climb.
And that's a state.
It is. Yeah.
Can we throw something out there just random without y'all thinking we're crazy? What if
I think it's Brandon.
it's Brandon? It's Brandon again. What would it be helpful to do, like a sliding scale for them based on their income when they're deemed indigent? That, I mean, and I guess maybe this is more for the judges, that you guys are having to go through, because I got what you were saying with, if I have 50 that are adjudicated to come through my court, then I've got to have that hearing, and I totally understand what you're saying there. What if it was easy enough to just do a sliding scale and say, all right, X income gets you X price paid for from the fund? Does that take some of that legwork out of it? Just an idea. I don't know if it makes any sense or not, but
I mean, if your statistics are I'm not doubting them, but the statistics about only 10% of your folks act paying anything, then obviously, I mean, I would love to be able to go to our colleagues and say, here's I mean, as judges, we kind of balk at scales, but if you give some discretion, obviously, I think that would certainly be upheld. And I think that, yeah, I mean, I don't disagree. Anything that we can provide those folks that you guys are saying are not paying anything, or requiring them to pay anything, that would help that problem.
well, and I can tell you this too. There's no guesswork on that less than 10%.
Could you send that? Could you send that information to distribute for everyone to see?
I think Nicole sent that to you, but I mean, you're happy to share it. But when you you sent us something telling us that there was 204. So Chad and I work on behalf of the coalition, but we really truly represent two of the manufacturers. Those are coming from those two manufacturers' internal numbers, and we ran those last night. Those were verified. There's
So that may
$204.
not, that wouldn't represent the other manufacturers and what people might be paying for them.
I would think that based on the population sample that we used, we have approximately 204. I think we're right at 204 people on indigency right now, receiving indigency funds, and it was what, 20 that actually pay something, and whether it's $10 or $20 or $50
or $5.
Yeah, I mean, that number was an accurate sample from what our current base is for Smart Start and for Simple Interlock. The Treasury may have an accurate, they may be able to pull that number because they track who is to pay and how much they are to pay. So Treasury may be able to provide an accurate number as well, as far as all.
Yeah, I was actually looking for that. I don't have that available right now, but I can do some research.
So we'll have that for hopefully the next meeting and what everyone's paying. Can that be broken down by counties? I know there were questions, if possible. I know there were.
Okay.
Okay.
If we can get it.
And manufacturer, do y'all know the manufacturers or no?
We do know the name.
Okay, that may help too. If we have some manufacturers who are,
I will say this, we charge something because I was advised, I guess when I became a judge, that the fund wouldn't pay if we didn't charge anything. And I never sat down and took the time to read the statute. So that's why all of us in Hamilton County charge something. And so if we could just say that and that was state, you have to charge some.
We need to put that in the
Yeah,
statute.
something they must pay some portion.
Yeah.
If you could put that in there, because anybody can pay $5. I mean, the way I always say it is they pay more than that on their alcohol, right?
And like like Brandon said, it gives them skin in the game, it gives them
Mhm.
reason to.
yeah, and we pulled the numbers of people in the program right now, and it stays for the past 4 years, it's been about 10,000 and some change, and I'm assuming this is because of COVID. This June, we're tracking over 12,000. So we're already up 2,000 this year compared to the last 3 years prior. So.
And just, you answered this earlier, but so for the new law, the pretrial interlock, there's some money appropriated, but then after that money runs out, that's gonna pull from the fund as well, or do we not know?
I'll defer to John on that one.
It shouldn't pull from the fund. It should pull from, well, I guess it will pull from the fund and we'll end up having to backfill it like we've always been doing.
Because there's only about
Because the money that was,
8,000 allocated.
yeah, that's what the fiscal note said, so that's what the general assembly appropriated. And that's supposed to be the amount that's supposed to cover those folks for that fiscal year.
So that was the estimate on new arrests that would qualify. Way too low.
It was much higher last year, so I don't know how. That's a y'all question on.
I will say on ours is through the roof, obviously, on our non-interlock. But Hamilton County, we own our own,
Right.
We contract with our own. So the judges there are more likely to use it, I'm told by the other judges across the state, who don't even know who to contact is what they say. And so that's probably why we use it so much more, because we actually have our equipment right there.
But I guess are y'all saying that that's not really separating them out isn't an option, or I know that some of the presentation talked about it, or if that's not that
Separating out the
the
fund.
two funds, is that
So accounting wise, they are separated.
They are,
Right? We track
I
them
got you.
separate.
So
It's more of an operational efficiency issue. You know, we use the same staff to process the claims, same software system platform to process those claims. So separating them operationally would then require us to duplicate resources. And I don't, you know, we can, the number of claims vary, fluctuates between the 2 months. And we know how many to staff for a total. If we had to separate those out operationally, make us duplicate our operational costs.
but y'all aren't saying the problem is coming as far as fund levels are coming on the interlock side is what everyone's saying. It's not, I mean, no, that's what we've been talking about. It's not really on the other form of the money.
Well, we just
There's a problem with both.
we discussed last time that
We're running out of
the
money.
surplus is supposed to cover all of the other things, but there is no surplus. So
Okay.
Right.
So it is affecting
Yeah.
both.
Yeah, and I think the conversation about splitting is more about like disassembling the ties with the spillover falling in. I don't think we necessarily, someone correct me if I'm wrong, necessarily want to split it out and have necessarily some other agency do it. But just having them be actual separate funds where the money itself is not tied to one or the other. So having a separate alternative monitoring fund that isn't tied to ignition interlock related fees, CUI related fees.
because there is no money, y'all correct me if I'm wrong on, there is no money, and y'all can see Kelly's comment up there as well on what they're requiring in Knox County. But there are no fees from convictions being put into the other type of stuff unless the county decides to opt in. So like with DUIs, a percentage of the DUI court fees are going to this fund. There's no
That's what funds
corresponding.
it, and then the county puts up half of the cost of alternative.
So there's no money going in to fund the alternative technology from the convictions itself.
Elizabeth, correct me if I'm wrong. Didn't we say it was like $40 off of each DUI that goes in there?
Yeah.
Roughly, but that's just a one-time fee
Yes.
that goes in there. That's what I was thinking. Okay, thank you.
And a portion of that, I think it's $30. This is Roy West, Department of Treasury. I think it's only about $30.75 that actually makes it to the EMIF fund. The other portion goes out to, there's a couple different agencies that do different things that are tangential to DUIs. And so they get some funding from that $40.
So to recap the first part of what he said, it's about $30 that goes into the fund from that 40. The rest of it goes elsewhere.
And there's no funding source from the transdermal monitoring that.
Correct.
Have we thought through the options for revenue solutions for the non-interlock side yet? That's something that's.
I put that on the agenda for today and for next week, so that's a safety will stay out of that conversation since it is not DUI. Yeah, sorry, next meeting. Next meeting.
This is Chad Ross. This is probably a question for Treasury. There was a question about whether there was any other money coming in from alternative electronic monitoring. Is there not a mandatory contribution on domestic assaults that's paid to the fund for GPS? There's a GPS monitoring fee, I thought, that was paid on a domestic. Does that not go into the fund?
There is domestic fees, and Roy probably speak to this better. He mentioned it last time, but all that money still goes into Interlock first.
Yep, and it's a very small amount. I believe it's what, $6,000, $6,000 a year.
So you're correct. That money is meant for non-interlock technologies, but that's not the way the fund is set up. So you could arguably look at all of those non-interlock technologies and charge a fee to those offenders committing those offenses, but I think we'd be back here in 5 years with the same problem. Because you have under collection. And we've seen time after time, and not only this, but other areas of the criminal justice system, that funding based on fines and fees isn't working.
And not working because about 70% go uncollected, maybe a little bit higher than that.
So we've kind of dabbled into the follow-up research section of the agenda. So while everyone's kind of pondering that, I wanted to touch on a few things that we had pulled. As we discussed earlier, the reasoning for the payment plans and the fact that the DUI isn't allowed for it after that revocation period is something we discussed. Again, not sure of why that decision was made. I would assume it was made a while ago based on the fact that you want to make sure DUI offenders either get held accountable or that this revenue is collected. So that may be something anyone who was in the General Assembly that long ago, I'm not even sure when that was put into place, but we discussed that and it's an option to be removed.
I think better than removed.
Or allow for.
Restricted for longer than a year, and then they would stay. It seems that y'all's evidence is that they would stay on that payment plan if they could.
Well, so how the driver's license stuff works, if we were to extend the restricted license period, that the restricted license period only coincides with the revocation period. So from our standpoint, if you extend that, that means that you're going to extend their revocation period and which would then be outside of the penalty phase.
Well, what I'm saying is we're amending the statute. So
Right.
You could say, right now, this is how it works, but moving forward, that revocation phase ends, and you still owe all this money, you can't get your full license back until you pay all that money, but we will grant you a restricted license if you continue on paying.
Yes. Another option, again, just because we had the payment plan bill a couple years ago and we just redid all the DUI stuff this year. Since we have the payment plan process in place, why not let it just be treated like any other court cost or fine for those traffic offenses, so that you don't have to create a whole new type of revocation restricted license plan. We just use the one that's already in place,
Yeah. When they,
because we would revoke it if they stop making payments
yeah,
anyway.
so they already have kind of a
Yeah.
special license.
Yeah.
That's gonna get revoked if you issue
Yeah.
the plan.
We already issue a
And what
restricted
in
if you get
there
revoked.
with it is that if you miss your
Right.
payment, if you miss your payment now on your DUI, then
Just like if you missed your payment on your 7 speeding tickets.
Okay. Just want to make sure we set some account.
Since that's already in place and it took us 2 years to develop.
Yeah, no, I mean, as long as there's a.
We'll use it. Okay, so again, I think the only thing we would check on, obviously, Chairman Bell knows this very well. We get a little hesitant when we're talking DUI laws and federal road money. So obviously we would want to make sure that there's no federal requirement that this be done, which I can't believe that there is, but that would be the only thing that we would check on our end. But just throwing that out there.
Is there a way to look at how many people, I think you could pull the stats, actually ended up losing their license after their period of having it open 1 year before they, you know,
Okay.
since they hadn't paid their cost, if we could get the figures from that. Right.
So how many people lost their license after the restricted revocation period for
Yeah.
failing to pay court fine and
Right.
cost? Okay,
Are there
I
a
can-
huge number out there?
we can look. I'm not sure if our system will break it down that way, but I can definitely check and see. And again, that number is going to be a tad skewed because we stopped revocations in 2018, as you all know, and didn't reinstate them until a year ago. So there's a lot of discrepancies and backlog there with that federal case that came out. But I'll check and see if we can get those numbers.
Can we clarify what pool of people that is? Because I thought you were saying you can't get it back until you pay.
So
Which pool of people are we talking about? Are we talking people who pay and then get it back and lose it again for not paying some other?
So how it works is someone gets convicted. Once you're convicted, we're going to go DUI 1. You have a 1-year revocation period. The judge can allow for you to drive during that revocation period. You get issued a restricted license that requires interlock. During that 1 year, the court will allow you to make payments on those court fines, fees, and costs.
Right.
And then once that revocation period is over, we will then issue you an unrestricted license that will either not have an interlock code or will have an interlock code, depending on if you got extended or if you didn't have a full year yet. But we will only issue that unrestricted license if you can prove to us you've already paid off all of your court fines and costs. So if you didn't within the prior year, we can't reinstate your full license. So that's what she's talking
So we're
about.
talking
And you
about-
lose your restricted. too.
You lose your restricted
So
too.
we're not talking about people who got it and lost their time, that aren't getting it back because they.
Because you would have to pay before we would even get you out of the restricted phase. And that's where I don't know if we have that, because it would just be people that we just never issued.
Right, that's what I was.
So,
Negative.
Yeah, we could tell you how many people had a restricted license that maybe didn't come in to get an unrestricted, but then that would also catch people that still, I'll do some digging, but
just so everyone knows too, I mean, it's somebody thinks they're paying off their DUI, so they can get their license back, and the court clerk is assigning it to an old case from 5 years ago. They go make their payment, they're not even putting it on the DUI. So that's another, again, I think this solves all that. It allows the DUI to be, because right now I'm having to tell people, if you go make a payment, you tell the clerk, put this towards my DUI, because you will never get your license back until you get that paid off. But so that would take that step out of it by allowing this
Right.
DUI to be lumped in.
they'll put it on like the speeding or accident associated with it or something.
Or an old drug case or an old assault case. I mean,
Right.
because they don't, these folks have a million cases and they just put it on anything. supposed to be credited towards.
The next thing we had was pulling the DUI arrest conviction numbers and offenses that we went through earlier, and I've shared with you all. We broke it down by county. Is that only THP though?
No, that's.
Okay, that's everyone. Okay, that's good. We weren't sure if we could pull all of them, but we do have those. So you can all see that we've broken it down by county, how many arrests we've had since 2013 versus how many convictions we've had. We can go through that again if y'all want to go through it. Everyone has it to review, so I'll kind of leave that up to y'all if y'all want to dive into that.
I think we need one more data point, which ECD might have, which is to have poverty rates readily accessible for every county. It's because, to Chairman Bell's point, last week we were looking at the breakdowns spending or breakdown of invoices approved per county. And we saw that Hawkins, for instance, was very high, even though it had a smaller percentage. So Hawkins ranks the fourth highest, and I'm looking at just Ignition Interlock because we're just talking about DUI convictions. Hawkins County ranks fourth in Ignition Interlock spending from the fund, but they're 26th in DUIs. So that's a pretty big difference. The only thing I think to maybe account for that is poverty rate, so that might help.
It's part of the
Qualify.
Yeah, we haven't accounted for that much, so it could.
Right. A more egregious case is Murray County is the second highest spender in Ignition Interlock, and they rank 44th in the amount of DUIs.
44th from the top, like
they're the 44th highest county in DUIs.
But they're pulling the second of
highest
funds.
spender. They spend the second most.
How many does Murray have per convictions? Oh, wow. Okay. Yep.
And I wouldn't think Murray County would have the same property issues Hawkins County.
So for example, Murray County spends per capita per offender $1,019.34 per offender, whereas Knox County spends only $133.70.
Is that monthly or annually?
Annual.
Okay.
Annually per person.
So that's more paying for
Based
all
on-
of it every month versus a fraction of it.
21. So Murray County's, they're paying over 600% more per person.
So you must have a lot of old DUIs coming back and getting their interlock. It's 58. I mean,
Or they're just paying all of it and granting indigency to everybody.
That's the point.
That
So
may
if
be
we
the
can
problem.
If we can see the poverty
yeah,
rate,
who the judges.
I think that's the third data point we need to see how skewed things are.
But the poverty numbers would be nice because you could at least control some of these by if you get out of it.
Yeah, there's ARCs. Their index is probably, it pretty much ranks every county in the state. So
So that would be helpful to compare that to this and see, okay, well, maybe there are just that many people who would potentially be injured because it's such an economically distressed county. That they
to be honest, I think you could probably
That's when.
we know which ones are distressed counties. Probably
Okay.
one person.
Is
Probably
that
pretty obvious.
It would be nice to have the actual data. Because I think like we talked about last meeting, there's a potential for having some sort of formula this funding is based off of, which would take into account DUI convictions, poverty rate, pretrial population, those sorts of factors. So we were appropriating an appropriate amount of money for county.
And to piggyback off the conversation from earlier, if you're talking, I think the bill from this year dealt with second offense, right? That would be how many since 2013 DUI twos we had, but
So instead you included like if you had a prior reckless driving, if you had a prior
Yeah.
reckless sedan.
but a caveat on that, which drives our department a little wild, is and again, nothing wrong with this, but we had to tweak our laws for this. You can see there are 115,000 DUI ones. Those could be people who have had multiple DUIs, but they're only being charged as DUI ones.
Right.
So that also doesn't take into account that we base it off how many you have on your record, not what the actual offense coming into us is. So also keep that in mind with these numbers, is that that's going to throw it off a little bit too. I had a guy yesterday who had 3 DUI first within a 2-week period. So, and the judge, they were all DUI ones. So, or maybe one was a DUI too, but that's also going to throw it off a little bit on who could be eligible, because I don't know how that would play into who could qualify for the fund as well.
And just one other, I guess, possible explanation for some of these numbers. As I mentioned before, some judges or district attorneys might be including the actual interlock process in as a condition of their probation, whereas our current district attorney does not. And so I have no authority to force somebody to. So a lot of folks in Hamilton County probably go without ever touching this, and they just say, I'm never going to drive again. Whereas in Murray County or Hawkins County, they actually might be requiring as a condition of their probation, they're on this interlock. So I'm not saying it's going to account for that much, but it's possible that some counties on here are requiring as part of their probation that they be on that device, whereas others, they're just choosing not to drive.
Yeah, the code is very discretionary to the judges. Even at arrest, they can require interlock if they choose, or they can deny it if they're like, you've had 5, we're just taking your license. So it is very discretionary when when the judges want to require it. We only come into play once we receive it after conviction. And that's when the fund obviously comes into play. The next question that came up was number of DUIs, alcohol versus drug. We can't determine that. It's not broken down. We would have had to have pulled all 120,000 DUIs and gone through each arrest report and tried to determine it. So it's just not captured that way. Yes.
I'm on the impaired drivers, we've changed the name of it, advisory council. And you're never going to get it really, because if it's 0.08 or above, they don't even test for drugs.
Correct.
It's just so sad, we'll never have.
Yes.
But I know that's a financial decision.
Yeah.
For the TBI. But that is real sad that we can't. No, because I bet the percentage is high that it's
there's from our notes and the arrests we've seen, there's definitely a high number of drugs, but there's also normally some alcohol involved. So you're right, as soon as they see it's above that 0.08 threshold, they don't test for anything further unless they're instructed to. So, but there's no way for us to tell without changing how those cases are reported or tracked. So we can't break that down.
But you
for everybody.
Get it broken down by what's available.
Yes. The next point we had was number of DUIs triggering revocation versus, and I think the biggest question we had was how many unsatisfied costs there still are for DUIs within each court. Let's see. We received some of it. I still do not have all of it because we reached out to AOC and then the general sessions separately. And so general sessions is still pulling data, but the AOC, I can defer to, I think Michelle and Charlie, they had another meeting, so they may not be on here.
Yeah, just find out. Michelle's texting me.
Yeah. But I believe they're also still trying to gather all of that information because they have to reach out to each of their courts. So still coming, but still coming on that information. I know that I was working with John Eskew for the general sessions and everybody, and they're trying to break it down, and it's just a lot of data they're trying to gather.
But there's still fees.
What would be the ones that we wouldn't have? We would only have the ones who are revoked for that reason. But that goes back to the conversation of why are they treated separately for the payment plan stuff. So that may play into it, as those people just don't have the option of a payment plan anymore. So, but once I get that information, I'll be sure to forward it out to everybody. Let's see here. Well, the The other item that was on the table for today was how to operate and split the funds. I don't know if everyone was done with the discussion of the indigency definition. Sorry, I kind of jumped in there. But this kind of, I think, maybe plays into that as well. Is I think we've got these two outstanding factors of what is the definition, how is it being used, and how is it being used across the state? And then also the other open-ended item is, do the funds need to be split? And if so, how do they need to be split and funded? So that's kind of gonna open it up to everyone there on that.
And I will say too, I know Michelle and the AOC, I mean, that we've worked in the Supreme Court as far as indigency definition and determinations in court for many, many years, going back to when we started the, Indigency Defense Fund. And so I know they're going to have, obviously suggestions and they certainly need to be there. They need to be in this conversation, because I do think even though it is separate, I mean, I think they're going to ultimately kind of blending in when you're having an indigency hearing, whether it's concerning appointed counsel or this. I mean, I just want to make sure the AOC is at the table for this, on this point as well, because I know they worked a lot on this, on their our definition when it comes to appointed counsel.
Making a note that for the next meeting, we definitely want to try to focus on fixes or things that need to be included or determined for indigency, as well as how best to regulate or operate the fund.
If you just move the percentage down like you have, you're gonna help us a lot, because right now, the way we look at it, it's black and white. I have them put what they made, and if it doesn't meet that criteria, I'm like, sorry.
But if the statute did say something as this of the rebuttable presumption and additional questions could be asked by the judge or investigator, I mean, something could be clear in the statute that would provide some judges who might not be doing these things, because we may already have the power to do that, but it would allow them to maybe do some of the things that Chairman Bell would prefer that they do.
Seems to me like this bullet about operating, potentially splitting the funds is kind of a secondary topic to tackle after we kind of determine the mechanics of the fund and the structure of the revenue stream. Y'all agree with that? And maybe we kind of nail down some of these, mechanics of the fund itself, and then follow back up in the next meeting or two about exactly where it's hosted, how it's set up. Things.
I would tell a joke for filler, but I'm not a very good joke teller, so.
Silence is deafening.
That really wraps up the agenda for today. But we're kind of at the point where, is there anything else need to discuss, need to put on the agenda for next time? The agenda for next week is next meeting is not very much, because again, remember, we have to have this report done by, I believe it's the end of September. So we're already, August 1st is Monday. So we're looking at, not too much longer. So we only have 2 more meetings, I believe.
Statute just requires recommendations.
Yes. Yeah, like a report of a recommendation. Yeah. So with 2 meetings, do we feel like that's enough to next meeting focus on kind of what we're narrowing it down to, what we're wanting to include, what we're maybe wanting to recommend, whether it be statutory changes, fiscal changes, whatever that may be. And then the goal from the initial meeting was that we have a draft report ready by that last meeting of all the recommendations to be reviewed and distributed Does that still seem realistic, or do we need to add another meeting in there? Want to gauge based on all the conversation and what work we feel like we still have left.
I think you probably need to see how the next one goes.
Let that be the litmus test, see how the next meeting goes, and let be the litmus test if we need to have another one.
Yeah, it's on August 9th. And then I believe the last one was scheduled for the 13th of September. So we definitely have some extra room in there with a month in between that third and fourth meeting if we need to add some more stuff into it.
And every judge in the state, every general session judge in the state will meet that last week of September. We all gather together. So if there is a report or recommendations, or if you want presentations to be given, that would be a good place to do it as well.
That last, you said the last week of August or September?
It's like September 22nd.
That's the second to last week. So
Yeah. Yeah.
Oh, the 21st, 22nd.
And the trial judges, I think, meet in October.
Have somebody come in from the department.
Probably our financial responsibility division. They normally go.
I think it's
I wanted them to.
Yeah.
About
him and Dana.
Oh, okay. Oh, it's the interlock team. Okay.
so they could maybe put a plug in.
They are.
We could, just say judges, you need to go.
Because again, I just don't know if everyone is even on our side is aware of this. And, if this money goes away, then, we want folks on these devices as and so I think if we make sure that all of us are aware of that, then, across the board, the judges in the state might put in a little more effort to make some time for hearings to do some of these things that they might not be able to currently, because the other option might be that we lose some funding and folks don't get on these devices that are so important. We can make that clear to everyone.
I know the team just met up with the clerks also, so at their conference.
Chairman Watson, I want to open it up to you if there's anything that we either didn't discuss or you want to focus on. I know from the finance standpoint, that's really where you want to, I don't know if the conversation was enough or if you want to have more discussion around indigency next week, if there is additional information you want. Wanted to make sure we covered everything that you wanted to go through today.
Yeah, I don't think I need any additional information. I want to look back at the statutes that we've passed since 2016 and the fiscal notes. I know I've glanced at them. But then I think figuring out the definition that on indigency, I think we're at a good starting point. I'm trying to understand how that pragmatically will be applied in the courts, just from a process perspective. So I don't want to create more problems by trying to solve this problem. So I think the people who do in the judiciary need to look at that definition and then think pragmatically about how would this be carried out. And then I think Chairman Bell's the request that we look at the data in terms of the utilization by different counties and then comparing that to poverty rates and such will be helpful to us. But for me, I'd like to, the next meeting, see if we can nail ourselves down on the definition of indigency and then rely on the courts to get this communicated to the judges. If it can be done pragmatically. I'm not interested in creating a whole new problem, though.
Okay. So I'll make sure on the agenda, the main subject for next week is the definition of indigency. I know that we also have a group that wants to come and speak. I believe it's the other group, not your interlock providers, but your other group who's going to do a presentation. There was also the request, the Treasury, they're working on the data that you just mentioned, Senator Watson, on what is being paid, what counties, what providers. So we'll have that for the next meeting. Hopefully we can have how many unsatisfied DUIs there are out there for all the courts by that next meeting as well. Let me think. I know that you all made the request that the courts come today to listen. Do we want a presentation from the courts based on any of this for next week? We can invite them to actually come and present something next week, or sorry, next meeting. I keep saying next week, next meeting, the 9th, or kind of treat it like today where it's open discussion. And I want to leave that up to the task force here, just because that was mentioned in our last meeting, that there be some actual data or information discussed.
Well, this is Bo. Again, I don't serve on judiciary, so I'm a little bit ignorant to some of the process and procedures that the courts use. I think it's beneficial to us for them to be engaged or do a presentation in terms of today I learned about how these indigency, do we have a separate hearing? Do we not have a separate hearing? Does that create a backlog in the system? So for me, as we discuss the definition of indigency, having the court folks represented so they can say, well, this is how this would play out in the courtroom, I think would be important to the task force to understand that. So that, again, as I said earlier, we don't solve this problem, but create a new problem in the process.
So it sounds like just have the courts available for the next meeting to listen to the conversation, provide any feedback or input around the crafting of that definition or that recommendation is probably. Yeah, perfect.
And since they promulgate the forms that we use, what goes into promulgating those forms that we've been talking.
And I believe,
there might be some separate discussions that like I said, they've had.
And I think Michelle and Charlie said that they will be able to be here in person for the next meeting as well. So that'll be helpful. And then hopefully we can have that information on how many there are as well with the treasurer's information. So that should develop some pretty good conversation. So we can just leave it kind of open-ended discussion instead of a formal presentation. That wraps up the, yep, John.
I have a question for Roy, if Roy's still on the call.
Yes.
Roy, you said that the $200 cap was only, did you say the $200 cap was only on alternative monitoring devices and not on ignition interlock?
I think he said the reverse.
The $200 cap is set for the plan as a lot. You guys mentioned that there was a cap on the DUI, the interlock devices that was less than. We talked about 125.
Yeah. So there's an install fee that can't be more than $225. There's a removal fee that can't be more than $75, and then the monthly calibration can't be more than $125.
Right. I just want to clarify that the statute does say that at least what the fund pays for cannot be more than $200 for any technology.
Okay. So then that makes sense since our cap is at $125 monthly. So.
Let's just clarify what we're providing. We're going to provide by county and by monitoring company,
right,
the number that how many pay, or the offender pays something versus nothing. Correct?
Yes. Is there anything else that we want to put on the agenda, or any groups or stakeholders that we want to invite for the next meeting?
Yeah. So we'll just go ahead and put it in the spreadsheet.
And I'm going to send, I'll send reminders out to everyone where information has been asked of so that you all have it as a reminder. And I'm also going to send out all of the documents we discussed today to everyone. So if you're not on the task force and you want that information, please get your email to me so that I can get you that information. And I'll just send out one email to everyone. We had IT in here earlier who told us how we can fix the speaker issue. So we will have that fixed for the next meeting so that it will pick up everywhere. It has to be dialed into on a separate device that has to be plugged in. So we'll do a test run of that to make sure it's all working very well prior to the next meeting. And then any information that I receive, I was sending it out as I received it last time, and that was just maybe too many different emails. I'm just gonna wait for any information I receive from everyone to send it out the day before with one group email of all of the information, so everyone has it in one place as opposed to various emails. I think that may just be better so people aren't going back in their files. So I'll do that as well to make it a little bit more efficient of a meeting next meeting.
Thank you. Apologize not being there in person.
You're forgiven, Travis. Okay, now we have just any additional comments, next steps that anyone on the task force wants to include? All right, and public comment for anyone who is either joining virtually. There's no one in person that hasn't been speaking, so anyone virtually that maybe wants to have any comments or anything they want to add or ask of the group, we'll open that up now. All right, I'm hearing silence, so yes.
James with safety. There seems to be an issue with people trying to join the link on the website. Talked to a few people who had that issue, but we'll work on that for the next meeting. Maybe see people in the public.
Again, we are the Department of Safety and we have no boards or task forces or nothing in our department. So we do not do hearings or groups like this ever. So y'all just bear with us as we're learning how to follow these rules and learn how technology has evolved since I learned how to use them in grade school. All right. Do we have a motion to adjourn? Do we have a second? All right. All those in favor of adjourning? Nays? We are adjourned.
Thank you.